By 1880, Rockefeller's Standard Oil controlled close to 90% of oil refining in the United States. But state corporate charters routinely blocked companies from owning businesses in other states, and Standard Oil of Ohio's charter was no exception. Rockefeller did not actually own most of the empire he ran. A grand jury had already indicted him and 8 other men for conspiring to monopolize the oil business. By 1882, he needed a way to run 40 companies without owning a single one of them outright. His lawyer found one, and the fix reshaped how every major industry in America got organized. To understand how, we have to look at the legal wall Rockefeller was up against. By 1880, Standard Oil was not one company. It was dozens of them, spread across several states, technically independent, but run as a single operation behind the scenes. Committees in Cleveland and New York tracked crude purchases, refinery output, transportation, and prices across the whole group. But enforcing one set of decisions through dozens of separate boards was slow, and it was getting harder to hold together. The deeper issue was legal, not managerial. 19th century states rarely let a corporation chartered inside their borders own stock in a business chartered somewhere else. Standard Oil of Ohio was legally confined to Ohio, even though its refineries, pipelines, and storage tanks already stretched across half a dozen states. Since 1879, Rockefeller had gotten around this in a shaky, informal way. 3 men, Myron Keith, George Chester, and George Villas, personally held shares of the out-of-state companies on Standard's behalf, acting as private trustees rather than as officers of any single corporation. On paper, Standard Oil of Ohio did not own those businesses. Everyone involved simply knew who was really running them. That workaround already looked fragile. In 1879, a Pennsylvania grand jury indicted Rockefeller and 8 other Standard officials, accusing them of conspiring to monopolize the oil business. The charges were about how Standard treated competitors and railroads, not about how its companies were legally organized. But the case put Rockefeller's whole operation under a level of legal scrutiny it had never faced before, and the shaky trustee arrangement holding the empire together was exactly the kind of detail that scrutiny could still expose. 2 years later, a different threat arrived. Pennsylvania tried to tax Standard Oil of Ohio as a foreign corporation doing business inside its borders. If one state could make that argument, any other state Standard operated in could try the same thing. In 1881, Henry Flagler, Rockefeller's closest partner, asked Standard's lawyer, Samuel Dodd, a direct question. Was there any legal way to hold and control companies across state lines without running into this same wall every time? Dodd did not have an answer yet, but he was about to find one that nobody had used quite this way before. Samuel Dodd was an odd choice to become the architect of the era's most consequential monopoly. He was a Pennsylvania lawyer, a carpenter's son, and had spent part of his earlier career criticizing railroad abuses. Rockefeller hired him in 1879, and Dodd would go on to refuse to personally own Standard Oil stock, worried it might compromise his judgment. The tool Dodd reached for was not new. The trust had existed for centuries, used mainly to manage property for people who could not manage it themselves. Orphans, widows, estates left behind after a death. Nobody had used it on anything close to this industrial scale before. Dodd's insight was that the law already let one person hand their personal property to someone else to hold and manage on their behalf. If shares of stock counted as property, shareholders could legally hand their shares to trustees, and the trustees could hold and vote them, all without any corporation ever owning another corporation. Later asked whether the idea had been his, Rockefeller said no. Flagler and Dodd had conceived it. He said, not him. On January 2, 1882, the plan became real. 40 companies were folded into the arrangement, 14 fully, 26 only in part. Their shareholders handed over their stock and received something new in return. Trust certificates, paper that represented a share of the whole combined pool, not of any single company. The scale of it was enormous. Standard Oil of Ohio alone had 35,000 shares, and each one converted into 20 trust certificates worth $100 apiece. 700,000 certificates in total, $70 million. Rockefeller's own shares turned into roughly 191,700 of those certificates, close to 27% of the entire trust. The certificates gave their holders one thing directly, a vote. one for each certificate, in elections for the 9 trustees themselves, held on staggered terms. But that vote never reached the 40 individual companies. The stock in those companies stayed in the trustees' hands, and only the trustees ever voted it. On paper, nothing had merged. Each of the 40 companies still had its own name, its own charter, its own board. But the shares that controlled those boards now sat with 9 trustees, Rockefeller among them. Whoever held the shares held the votes. Whoever held the votes could elect the directors and the officers, and the trustees could even elect themselves. Ownership on paper and control in practice had been pulled apart on purpose. A second agreement 2 days later gave the trustees one more piece of flexibility. They did not have to fold a company's actual property into the trust right away. They could leave its corporate shell standing, technically independent, for as long as it was useful to keep it that way. The result was one operation wearing 40 different names. Committees under the trustees tracked crude purchases, refinery output, and freight costs across the entire empire. The same coordination problem separate boards had struggled with a year earlier, only now backed by the authority to actually enforce one decision. Pricing, output, and expansion were settled by 9 men in a shared room, while on paper, 40 separate companies still appeared to be running their own affairs. The trust worked exactly as Dodd intended, and other industries noticed almost immediately. Cottonseed oil formed its own trust in 1884. Linseed oil followed in 1885. Lead producers combined in 1887. That same year, distillers formed the Whiskey Trust, and sugar refiners formed the Sugar Trust. Standard Oil had not just solved its own problem, it had handed every other industry the blueprint. For years, the actual Standard Oil Trust agreement had stayed mostly hidden from public view. That changed in 1888, when a New York Senate investigation obtained a copy and called it, plainly, the original trust. Before 1882, the word trust meant something narrow, a legal tool for managing an inheritance or looking after someone who could not manage their own property. After the Standard Oil Trust and the ones that copied it, the word meant something else entirely. A small number of men controlling an entire industry from behind a wall of separate, cooperating companies. That shift in meaning is where the word antitrust comes from. In 1890, Congress passed the Sherman Antitrust Act, aimed directly at combinations in the form of trust or otherwise. Ohio's Attorney General went further, tracking down the original 1882 agreement and taking Standard to court in its own home state. In 1892, the Ohio Supreme Court ruled that the trust had illegally stripped Standard Oil of Ohio's own directors of their authority and ordered it dissolved. The dissolution looked like a defeat. It was not. The same men still held the same economic interests, only now spread back across the individual companies instead of pooled into trust certificates. Within a few years, Standard reorganized again, this time in New Jersey, a state that had rewritten its own laws to allow exactly the kind of ownership Dodd's trust had worked around. What the trust had done quietly, the new company now did openly, as a holding company owning its subsidiaries outright. Rockefeller never described the trust as something to apologize for. He said, the day of combination was here to stay, and that individualism was gone, never to return. He described the growth of a large business as something close to natural selection, the survival of the fittest playing out in industry instead of nature. Thank you for watching to the end. Dodd took a legal tool built for orphans and estates and pointed it at an entire industry. Was that brilliant lawyering or a loophole that should have never existed? Share your take in the comments. This channel does not cover full biographies. Every video breaks down one decision this deeply. Nothing more, nothing less. If that is what you are after, make sure you subscribe to the channel and hit that notification button so you never miss the next one.